And now we're going to discuss the case of the Manhattan Eye, Ear, and Throat Hospital versus Eliot Spitzer. Manhattan Eye, Ear, and Throat was a nonprofit corporation, and because it was a specialty hospital, it lost money constantly. It was projected to lose $5 million every year, and some consultants from PwC said, look, your business as a hospital has no value, but the underlying real estate in Manhattan has a lot of value. And the board agreed, and they said, let's sell the hospital and bulldoze it and build some luxury apartments. And we can get $40 million out of this deal. Non-profit corporations don't have shareholders. Their shareholders, so to say, are the public. And so Eliot Spitzer, as Attorney General of New York at this time, was representing the public, and he sued in something like a shareholder derivative suit to undo the sale. First question, which state's law will the court apply? And what's the rule? This is actually not a federal case. This is a case about corporate governance and whether the board made the correct decision. So it's a state law case. And it's actually not Delaware. What is the rule that you would look to for a corporate governance case? State of incorporation. Jared has it, so perfect. And the correct answer, as Michael says, is the state of New York. So because Manhattan Eye, Ear, and Throat Hospital was incorporated in New York, you look to the state of incorporation. So again, if this question is on the exam, don't do a knee-jerk reaction and hit Delaware. Look at where the company is incorporated, the company being sued, not other companies in the question. So when Eliot Spitzer sues, what is the legal issue and what are the elements of that legal issue? There's a legal issue, again, with 3 elements that would be immediately raised by the board of directors. Anyone know what that's called? So this legal issue is the business judgment rule. And the business judgment rule says that judges will defer to the actions of the board of directors so long as the decision was 1, rational, 2, informed, and 3, made without a conflict of interest. So once the board of directors invokes the business judgment rule, number 2 was informed. Once the board of directors invokes the business judgment rule, then Eliot Spitzer has to rebut the business judgment rule, and he does that by rebutting one of the elements. He says either this hospital sale was irrational or uninformed or a conflict of interest. So on the next slide, we're going to go through 6 pieces of evidence that the judge found during the trial, and you tell me whether the evidence pointed to irrationality, being uninformed, or having a conflict of interest. Okay, so piece of evidence number 1, Lenox Hill offered to take over the hospital for $50 million, and the real estate deal was only $40 million. Is this irrational? Is this uninformed? Or is this a conflict of interest? Perfect. It's irrational because the point of a corporation is to maximize shareholder value. So all things being the same, 50 million is more than 40 million, therefore this is irrational. Now number 2, the board did not consider the Lenox Hill proposal. There was no mention of it in the minutes, and Kim has uninformed. That is correct. The board has to do due diligence, especially with an important decision like this, and it has to record how it did its due diligence in the corporate minutes. Number 3, the strategic committee hired PwC for a 1% real estate transaction fee. And Bill says conflict of interest, that's exactly correct. If you hire consultants on a real estate transaction fee, they're going to advise you on a real estate transaction and ignore all the other possible alternatives. Number 4, the board was not aware of this fee. Saeed says uninformed, that's perfect. The board needs to be aware of what its committee members are doing and what its consultants are doing and how they're being motivated. Number 5, the board did not communicate with the doctors who were very concerned about the sale because the doctors were, they're biased. They're after their own self-interest. They're greedy. What is this? So this could be several things, but New York has a shareholder constituency statute. Normally, it's okay for the board to say, look, we're exploiting our employees, we're exploiting our independent contractors, we don't really care about them. That's fine because we're driving up the shareholder value. But in New York, because it has a shareholder constituency statute, the board has to consider all the stakeholders, not just the shareholders. And the doctors being employees and independent contractors, they're stakeholders, and this sort of language that the board is using is not helpful when the judge is trying to find a reason to uphold the board's actions. And the final piece of evidence is on the certificate of incorporation, the hospital is supposed to be run as a hospital. It's not some sort of real estate development company. And there are certain procedures to change the mission and the language on the certificate of incorporation, but the board of directors never followed through on that. So for all of these reasons, the judge said, okay, the business judgment rule does not protect you. Eliot Spitzer has successfully rebutted the business judgment rule, and as a result, the Manhattan Eye, Ear, and Throat Hospital still exists today, and it was merged into the Lenox Hill Hospital system. So I have a final point about the board of directors. This case was about suing the board of directors to undo a sale. What if you sue the board of directors of a corporation personally? And I'm going to show you a board of directors. This is the board of directors of Theranos, which is a corporation which has limited liability. The guy on the left is Henry Kissinger. The guy next to him is Senator Sam Nunn. And there are also 2 flag officers on the board. None of these people have any medical training or experience. So if an investor in Theranos were to sue Henry Kissinger personally because he intentionally caused the problems that happened in Theranos, would Henry Kissinger be personally liable, assuming that he actually did cause the problems? And the correct answer is yes, because directors are personally liable and officers are personally liable for destroying shareholder value. That's one of the most powerful things about a shareholder derivative lawsuit. Yes, they owe a fiduciary duty to the shareholders to treat them fairly and not destroy shareholder value, not destroy the value of their stock. So would Henry Kissinger be personally liable for an omissions or negligence, for not asking the right questions when there were doubts about Theranos? And the answer is yes, he has a fiduciary duty to shareholders that also applies to negligence. So where are these people now? They're no longer on the board of directors of Theranos. They've been moved off to other boards that are not the real board of directors, or they've disassociated from Theranos to avoid any more liability than they already have. So many of you are very high-powered students and have excellent professional practice already, and some of you may be called upon to serve as a director or an officer of a corporation one day. And one of the things you should ask when you get that honor is, give me a copy of your D&O liability insurance, your director and officer liability insurance policy, because that is what is going to protect you if you're ever sued by a shareholder seeking more money. Okay, now we're going to talk about Facebook. So there were 4 students at Harvard University. There's Narendra on the right, the Winklevoss twins in the middle, and they had this idea that, well, we can, at every college campus, we can create a computerized social network where you can look at all of your classmates and find out what their interests are, but they didn't have the technical expertise to actually build their idea. So they hired a programmer by the name of Mark Zuckerberg. And Mark Zuckerberg said, you know, I don't need to work for salary. And the other 3 said, well, how about we share our eventual profits with you instead? And Mark Zuckerberg said, okay. And none of these 4 people prepared a partnership agreement or anything in writing. What kind of enterprise have they just formed? Perfect. Thomas says general partnership. That is what they formed, a general partnership with no limitation of liability, because they decided to split the profits and start working together. Now, assume that they have profits. How would the profits be split? Perfect. Equally is the correct answer. And that's what happens when you don't have a partnership agreement that specifies how the profits would be split. And in real life, you would look to the partnership agreement first, but for the purposes of the exam, you don't have time to read a 70-page partnership agreement. So we're going to assume that there's no agreement in many of the questions. Now, the question will be absolutely explicit about that. So if this company, this partnership that they formed is called ConnectU. If ConnectU gets sued, who is liable? Yes, all of them. And would they be liable personally? Would they be liable personally? And Radhika says joint and several liability applies to all of them. That is correct. And everyone says yes, they would be liable personally. That is also correct. So general partnerships are very dangerous. Okay, last question about this slide. Zuckerberg does nothing for a few months. And then the Harvard newspaper comes out with this announcement. The Facebook LLC has just formed, and it's going to create a social network that connects all of us. What can the ConnectU partnership sue Mark Zuckerberg for? Excellent. Jared has breach of duty. It's the breach of fiduciary duty of what? There's a list of about 5 fiduciary duties, which would be good to review before the exam. But yes, Saeed says loyalty, so does Radhika. It's a breach of the fiduciary duty of loyalty. Specifically, Mark Zuckerberg is still a partner at ConnectU. So if he has a new or better idea of how the social network should work, he needs to clear it with Narendra and the Winklevoss twins, and he has to ask, do you guys want to use this first for our partnership, or may I go off on my own and do it? That's called a right of first refusal, which he did not give. The other alternative is he could have resigned from the partnership and went off and pursued his own competing venture, and then there would be no breach of duty. The breach of fiduciary duty comes from him being a partner at the same time that he sets up a competing company, because he's a partner, he owes a fiduciary duty of loyalty to the other partners. Okay, now let's take a look at the Facebook LLC of Florida. This is an LLC, and it's a member-managed LLC. So Mark Zuckerberg takes 65% of the equity. Saverin actually does not work. He doesn't know how to code, or he doesn't code that well. But he takes 30% of the equity in exchange for purchasing all of their computer equipment. And Moskowitz, who is Zuckerberg's roommate, has 5% of the equity. Now, do these 3 people owe fiduciary duties to each other? Yes is the correct answer, and that's because as member managers, they're simultaneously directors and officers and shareholders. And remember that directors and officers owe fiduciary duties to shareholders. So let me explain for a moment what this slide is showing. Facebook is preparing to take venture capital. And as part of that transaction, they need to reincorporate in Delaware. And there are two ways to reincorporate. The Delaware Corporation can purchase all of Facebook Florida's stock or all of its assets. Suppose that we're only looking at the top part of this slide, and it is a stock sale. The reason why they would reincorporate is because venture capital is interested in investing in them, and venture capital generally wants the Delaware Incorporation because they understand Delaware laws. So suppose there is a stock sale and Facebook Delaware purchases all of Facebook Florida's stock. Suppose then that ConnectU sues for breach of fiduciary duty of loyalty and also conversion and fraud and a number of other causes of action. Which entity would they sue? And Jared says all liability transfers to the new corp, and Saeed says Facebook Inc. And those are both correct. They would sue the buyer, the Delaware Corporation. And the reason is in a stock sale, you purchase both the assets and the liabilities of the corporation. And ConnectU is a potential liability of the corporation, and it transferred over to Delaware. And that's good news for ConnectU because it's the Delaware Corporation that also has the assets they can recover from. And in real life, they recovered $60 million. In the bottom half of the slide, an asset sale, suppose that this asset sale had finished. The Delaware Corporation now has all the assets of the Florida Corporation. Which corporation would ConnectU sue? Right, it would be, Saeed says, the LLC. And this is correct. They would sue the seller and recover from the seller. This is why during an asset sale, you don't take all the assets. You leave some of the assets to cover potential liabilities, such as this lawsuit, so that ConnectU can recover from the Florida Corporation and not bother the Delaware Corporation. What if no one saw this coming and nobody left money in the Florida Corporation? So ConnectU sues, they have a good lawsuit, they claim $60 million, there's no money in the Florida Corporation. What happens to ConnectU? Right, Radhika says the owners are liable, and Jared agrees. Yeah, and the owners are liable, but what is that legal concept called? Yeah, Craig says the corporate veil, and that's correct. It's piercing the corporate veil. So ConnectU would say, well, the Florida company was left undercapitalized. It couldn't meet the demands of its debtors, including ourselves, and therefore, even though it's a limited liability company, we're going to pierce the corporate veil. We're going to say there actually is no limited liability here, and we're going to treat everybody who benefited from Facebook Florida as this big general partnership and be able to recover that $60 million from everybody jointly and severally and personally. So that's how they would drag Zuckerberg and Savarin and Moskowitz, and particularly Facebook Delaware, which has all of those assets, into the lawsuit. Okay, now we go forward in time to when Facebook Inc. of Delaware is receiving its first venture capital. We have two new people. The person in the brown photograph is homeless man and Napster founder Sean Parker, and the person in the teal photograph is Donald Trump's nominee to the U.S. Supreme Court, Peter Thiel. And we also have this swimming pool diagram, which represents the option pool. This is stock that's left over, I believe, for the purposes of the initial public offering coming at a later date, but it can also be used to hire additional executives and give them an equity stake in Facebook. So notice what happens after in the first bar, after Facebook reincorporates in Delaware. Savarin has 34% of the company. But then Peter Thiel puts in his $5 million, and Savrin's ownership drops to 0.3%. So he's been diluted. Yes, and nobody else has been diluted. They're still at 51, 7, and 7. So Savrin has basically been eliminated as someone who matters to this company. How do we describe what happened to Savrin? Radhika says pushed out. That is close. He wasn't bought out because all he has are shares. Nobody paid him any money. So the language from the course, which I want you to pay attention to, is this is called a freeze out, where he used to matter in the shareholder meetings, his opinion used to matter, but now Zuckerberg and the others are saying, we don't want you here anymore. Even though you invested money, you had a 34% stake, we're going to dilute you and print our own shares until you're worthless. And then the other thing to know is that this is called oppression. When somebody freezes you out, you sue the courts and you claim oppression. And the remedy for oppression is, I can no longer work with these people, therefore pay me money, cash me out, and I'll take my money and go elsewhere. Remember, this is a closed corporation, so he can't sell his shares. He needs the other people to pay him money so that he leaves. And the final thing, which we keep coming back to, is breach of the fiduciary duty of loyalty. Mark Zuckerberg is the sole director, he's the CEO, and he's the controlling shareholder. This sort of thing cannot happen unless Mark Zuckerberg says to do it. So Mark Zuckerberg and Savrin had a falling out, and Mark Zuckerberg retaliated by destroying his interest in Facebook. Now, I'm going to repeat those three things because they might be important for the exam. This situation would be called a freeze out. He could sue for oppression, and it's also a breach of fiduciary duty. Now, what actually happened in this case? Savrin sued Mark Zuckerberg for his 34% back, claiming all three of those things, and his lawyers eventually settled with Zuckerberg's lawyers for 5% of Facebook. By the time they settled, the initial public offering had already happened, and 5% of Facebook was worth $2 billion. So what did Savrin do with $2 billion worth of stock? Well, he renounced his U.S. citizenship. And what that allowed him to do was escape capital gains tax. And because of that, he now lives with $2 billion in Singapore. And Radhika asked, there was a breach of fiduciary duty by Zuckerberg? Yes, because Zuckerberg was the CEO, which is an officer, and he was the sole director of Facebook as well. And directors and officers owe a fiduciary duty of loyalty to their shareholders. And they can do things like dilute all the shareholders if there's a good business reason, but going after one shareholder is problematic, as Savrin's settlement proves. Okay, if there are no other questions about that, let's move on to criminal law. Saeed asks, how did it go from 34% to 0.3%? Essentially what happened is that the remaining people decided to issue millions and millions of shares. So Savrin's shares didn't go down, but everyone else's shares increased by a dramatic amount, such that only he got diluted. And Saeed also asked, why couldn't Savrin do the same thing? Because Savrin's no longer in control of anything. Mark Zuckerberg ousted him from being a director back when they were at the LLC. He ousted him from being the CFO back when he was at the LLC. And now his ownership percentage has dropped so much that his vote doesn't matter at the shareholder meeting. And those are the three ways you can govern a corporation. Savrin no longer has any of the three, so he's effectively frozen out of the corporation. All right, so let's look at illegal insider trading. There's a company called Imclone with a drug called Erbitux that is going through the FDA approvals process, and the FDA delays their giving approval. So the FDA sends a memo to the CEO of Imclone, pictured here, and he types up a press release, but rather than releasing the press release, he decides instead, I'm not going to release this press release for 3 days, and instead I'm going to call my broker at Merrill Lynch and tell him to sell all of my shares. What are the elements of illegal insider trading? So very, very good. We're putting it together. It's trading while possessing non-public information, and the information was either wrongfully obtained or wrongfully used. So good job, all of you. Now, was there non-public information in this case? Yes, absolutely. It was because he never issued the press release, that information about the FDA delay never became public. Was the information wrongfully obtained? Correct. The answer is no, because he didn't steal this information from the FDA. The FDA sent it to him. But was the information wrongfully used? And the correct answer is yes. Yes. So you have 2 out of 3. You can establish a charge for illegal insider trading. Right. He had a duty to his company, the CEO, of using that information responsibly and not to benefit himself and destroy the capitalization of his company. So now suppose that you are a Merrill Lynch executive and your internal audit people show you this broker's records. He gets red flagged by your analytics software. Okay, what are you concerned about legally as the executive? And think about agency law, vicarious liability, and think also about corporate law and Henry Kissinger. Yeah, personal liability. You could, so let's go through everything one more time. Assume that this broker is an employee, right? Merrill Lynch could be vicariously liable for the broker's actions based on respondeat superior of an employer, because this broker was working out of the Merrill Lynch building. That's the place. He was working on the time that was allocated for him to sell the shares. So you have time. And the only question is illegal insider trading within the scope of Merrill Lynch's operations? And as we saw from the Wells Fargo case, where all of these Wells Fargo's employees were opening fraudulent accounts trying to hit their numbers, that's not a far-fetched argument. You know, maybe Merrill Lynch is fostering some sort of culture where brokers are supposed to illegally insider trade in order to make their numbers. So that's going to be one of your concerns. And the other concern is, well, if the government comes down on you for vicarious liability, then the shareholders may start suing you derivatively to get the value of their shares of Merrill Lynch back. And so they may even sue you personally, like I suggested with Henry Kissinger. So Said is correct. There's a need to come forward. Now the broker says, the broker also has Martha Stewart as a client, and Martha Stewart also owns a tremendous amount of Imclone shares. So the broker leaves a voicemail message on Martha Stewart's machine saying, I think Imclone is going to start trading downward. Martha Stewart hears this message and she calls the broker back and says, okay, if you think that, go ahead and sell all of the shares. So yeah, this is a crazy situation. Now, what the Merrill Lynch executives ended up doing was they had the CEO's trades, Martha Stewart's trades, and then immediately when that press release actually went out, the stocks tanked. So the analytics software red flagged this broker and said, we think he's doing something illegal. The executives followed Saeed's advice, need to come forward, and they called the cops. They called the SEC and said, look at our analytics report, and we want you to open an investigation, a criminal investigation into our broker, and we will cooperate with you. So the SEC said, yeah, this looks suspicious. I'm going to go ahead and call the FBI. The FBI sends special agents to interview Martha Stewart. Is Martha Stewart guilty of illegal insider trading? Okay, we have no, and that is the correct answer from the folks on top. And let's think about this. Did Martha Stewart have material non-public information? The correct answer here is no, because all the information she had is this broker saying, I think Implone is going to start trading downward. That is ordinarily what brokers say. They have these newsletters where they're making random predictions about the market. And the broker didn't pass on anything about like this memo being hidden or what the CEO did. That was the extent of the voicemail. So the insider trading charge fails because it doesn't have that first element. If you went on to wrongfully obtained, the broker gave her a phone call. There's nothing wrongful about that, so you don't have the second element. And then wrongful use, well, Martha Stewart doesn't really owe a duty to anyone in this situation. She's not part of the hierarchy at Implone. So there's no wrongful use either. None of the three elements fit because the broker had insulated her from any sort of tip or illegal knowledge. So you might be thinking, well, didn't Martha Stewart go to jail? And the answer is yes, she went to jail because the FBI agent sat down with her and asked her, what was the contents of that voicemail you got? And her response was, what voicemail? So she went to jail for 5 months for obstruction of justice, whereas the CEO went to jail for, I believe, 7 years and had to pay $4 million of fine. So Martha Stewart got off easy, but at the same time, she lied about something that was legal, and it was completely pointless.